Hey, who's this next speaker? Who's up next? Wait a minute. It's me. That's right. You've seen me on the screen before as the interviewer, as the MC, and this is actually my talk. It's kind of fun. My name's Greg Newby. I've had a lot of involvement in the conference so far, but today I'm excited to bring you a story of something that I'm involved with personally. And let's just go ahead and roll the film. It's not too short, and then we'll come back and have some questions and discussions about this whole thing with Project Gutenberg being sued in another country as a small public charity. Let's get to the story. Hello, I'm Greg Newby. Thanks to the Hope Conference for having me join you here today. I'm going to tell the story of how Project Gutenberg fought, lost, and learned from an international copyright lawsuit. Let's tell that story. For reference and completeness, here's the abstract that I submitted for the talk. Let's not focus on that. Let's keep going. The main player in this story is Project Gutenberg. Project Gutenberg is an online library of free ebooks or electronic books. It is one of the oldest online content providers in the world, having started in 1971. Project Gutenberg's mission is to encourage the creation and distribution of ebooks. New Project Gutenberg ebooks are based on published works that do not have United States copyright protection. These ebooks are selected and digitized by volunteers. You can find Project Gutenberg online at www.gutenberg.org. One of the other main players is me. I've been the director and CEO of Project Gutenberg since the foundation that operates it was formed back around 2000. There I am on my dog sled enjoying some quality time with my four-legged friends. I have a diverse background and a lot of interests, but today we're focused on Project Gutenberg. With Project Gutenberg, I'm a volunteer. I manage other volunteers. I also take care of the many administrative details of the organization. The game plan for today's presentation is I'll first describe how Project Gutenberg selects new ebooks. I'll talk about the lawsuit and the 18 ebooks that were the subject of the lawsuit. I'll describe what we did in response and spend some time talking about what we learned and especially how our lessons might help you. But wait, I don't want to leave you hanging. Let's jump to the conclusion. The most important things for you are don't fight a lawsuit in a place that doesn't have jurisdiction over you. The other important learning that I share is make sure you have qualified legal advice specific to your own situation. Don't take the advice of others, even at the Hope Conference. I'm going to give you a quick summary of how we select new ebooks for Project Gutenberg. This is important to the lawsuit. There are a couple of links here that show details. Essentially what we do is we add items which were previously published by a bona fide publisher and are proven not to have copyright protection in the United States. We have an extensive set of procedures for this. The bottom line is that when items that were copyrighted reach the end of their copyright protection term, they enter the public domain in the United States. Items in the public domain are owned by you, by me, by everyone, by the people of the United States. There's no copyright protection. Historically, we added a number of other item types, but these days, this is all we do. We digitize and distribute previously published works which have no copyright protection in the US. The whole principle here is unlimited free redistribution wherever it's legal to do so. Those procedures we linked to on the previous slide are exemplary. When we determine something is in the public domain in the United States, we're really quite certain about it. We've demonstrated our due diligence. Now, we don't pay attention to copyright law elsewhere because we're based in the United States, and we have a very clear terms of use on the website that says, this is free for use in the United States. You need to check the rules of your jurisdiction before downloading. Different countries have different copyright laws. In the US, anything published prior to 1978 gets 95 years of copyright protection after publication. This is what we usually utilize for Project Gutenberg works. In most other countries, duration is based on the author's death date, and this means that there can be things that are copyrighted in one country and not copyrighted in another country. The procedures for these differences are guided by the Berne Convention and something called the World Intellectual Property Association. There's also various bilateral and multilateral treaties. Bottom line is that a country needs to give the same protection in its country no matter what location the publication originated from. So in other words, in the US, you don't give less copyright protection to something from Germany or England or elsewhere. You give the same protection as in your country. And in turn, those other countries need to extend the same protection in their countries. Wow, copyright is boring, huh? And international copyright procedures, even more boring and procedural and fraught with some uncertainties as well. Let's get on to the thing that's more exciting. In the late days of 2015, Project Gutenberg was served its very first ever lawsuit. Project Gutenberg was sued by Fischer Verlag, a German publisher. We were sued in a German court. The lawsuit demanded takedown, in other words, removal, of 18 ebooks by 3 authors in order that they were impossible to access from Germany. The lawsuit also ordered that we disclose how often these books were downloaded to Germany, that we pay license fees for the 18 books, and that we pay the court costs. During the lawsuit, we found that there were never any times that these books were downloaded to Germany that were proven. There was never any evidence that they had ever been downloaded to Germany. And the court didn't ask for this evidence, despite Project Gutenberg saying that our terms of use were sufficient to stop people from violating Fischer Verlag's possible copyrights in Germany. Also during the lawsuit, the German court accepted truly insufficient evidence that the plaintiff actually owned the copyrights. In a US court, these two facts would have been totally different. They would have started with firm demonstration of ownership and then went on to demonstrate actual injury, actual downloads. These things didn't happen in the German court, and the German court didn't even care. So what books are we talking about? What authors? When were they published? In what language? The 18 books were by 3 different authors. The first of the books was published in 1897, over 120 years ago. The last of the books was published in 1920, just now 100 years ago, or 95 years ago when the lawsuit was filed. The 3 authors all died in the 1950s. In Germany, copyright protection extends for 70 years after death. So the authors were still in copyright. One of them is no longer in copyright because the lawsuit's taken 5 years. The German lawsuit made a big thing out of the fact that Project Gutenberg has German content, and we even had some old translated web pages from English to German. This seemed to be the main evidence given to the court that we specifically target people in Germany. This is simply false. We don't. German is the 4th most common language in the Project Gutenberg collection. It's also around 3% of the collection. Germany is not targeted. And even the extent to which German is a language of interest, well, in the United States, German is the 2nd most frequently spoken second language in the whole country. So there's people that speak German in many different places, not just Germany. Fischer Verlag and the German courts agreed these items do not have copyright protection in the United States. They've been in the public domain since as early as 1957 or as late as 1976. In 1957, Chuck Berry was a big thing. 1976, Kiss was a big thing. These are long ago times. So why did we fight? Why didn't we just remove the items and avoid the lawsuit? Well, we've received occasional takedown requests over the years, and we know that we're right, that we're not subject to laws outside of the US. but we were never sued. There are many items in the collection that are copyrighted elsewhere. We wanted to fight because we don't want to handle a torrent of similar complaints from Germany and elsewhere about things that might be copyrighted where they are, but are not where our online library operates. We think that it's sufficient that the website in each book has the terms of use saying, hey, these are not copyrighted in the US, they're free for use in the US, but you got to check your own laws, your own guidelines before using them elsewhere. And so we fought. We engaged with the German plaintiff and court system on matters of fact and matters of law. We would do things differently if this were to happen again. Instead of addressing the substance of the lawsuit, we would instead simply restate that only a U.S. court has jurisdiction, and any lawsuit must be within that court system. We did present a robust defense. Over a period of 5 years to 3 different courts, we repeated at every opportunity that the court has no jurisdiction, that the case must be brought to the United States. We also pointed out that Project Gutenberg has no operation in Germany. We do not target people in Germany, and the fact that there is some German language content on Project Gutenberg doesn't matter. We still have no operation in Germany and do not target people in Germany. We confirmed repeatedly that there are no records of anyone from Germany ever downloading any of the 18 books, and the plaintiff was never asked to provide any evidence of downloads or any evidence of injury, such as whether they even sold these books ever in their own bookstore. We pointed out the deficiency of the plaintiff's demonstration of proper ownership in Germany. It turns out that some of the documents demonstrating that the Fischer-Verlag company has ownership were actually signed after they sued us. What about that? We explained the nature of Project Gutenberg. We're an all-volunteer charity library. Our budget is based on donations and really just pays for a quarter-time office manager and hosting expenses and related things like that. We're a low-budget operation. Everyone's a volunteer, including me. We described the collection development process and the fact that volunteers select and digitize the books. I didn't select these. I simply approved that they were in the public domain and therefore eligible for the Project Gutenberg collection. There are no flaws in our decision to digitize these 18 books. As I mentioned earlier, our procedures for copyright are exemplary. We also pointed out that the United States Constitution's guarantee of freedom of speech means that we can do as we will with these public domain books, and that to be quelled, to be told that we cannot distribute these books, is actually an infringement on our First Amendment rights. We made other arguments as well. All of these arguments seem to fall on deaf ears. So what happened? Project Gutenberg lost the fight in the German court system. When we appealed, we lost the appeal. When we appealed again to the higher court, we lost that as well. Interestingly, though, the German court specifically did not order what the lawsuit asked for. They said the items did not need to be removed. They did not need to be impossible to reach from Germany. They just needed to be more difficult. In other words, we could use something like geo-IP blocking rather than actually removing the books. The plaintiff said this was insufficient, and they argued a lot that we had to remove the items entirely. So the German court agreed with us that we didn't need to remove them, and yet they claimed that we had lost and ordered payment of court fees and fines. Project Gutenberg is no longer accessible from Germany at www.gutenberg.org. We applied the geo-IP block as the court requested. This wasn't because we agreed with jurisdiction or anything like that. It was so that we wouldn't antagonize the court during the appeals process. We're ready to remove the block, but we're also in settlement discussions with the plaintiff. One of the things we learned is there's something called enforcement of foreign money judgments. When a U.S. plaintiff loses in an international court, if that international plaintiff wants the money to be paid, they need to come to the U.S. court to get an order where there actually is jurisdiction in the U.S. This would be the next step if we don't reach a settlement discussion, and of course, if we don't voluntarily pay the German court system. Foreign money judgments may not be enforced by U.S. courts under a variety of circumstances. One of those is if the judgment is repugnant to the public policy. You can bet that we think that a foreign plaintiff and a foreign court pursuing action against a small charity library due to its online activity is going to be found repugnant and unenforceable in the U.S. court system. So let's sum up what we learned and what it might mean for you. Here's a summary of some of our lessons learned and a few things we might have done differently if we knew then what we know now. The main thing is that foreign courts do not have jurisdiction over Project Gutenberg. We did not need to show up in the German court other than to point out this lack of jurisdiction. It was probably not necessary or even helpful to address matters of fact and matters of law, which we worked so hard on. Restating the jurisdiction issue would likely have been sufficient. I'd like to guide any organization in this situation to make sure they get qualified legal advice. Our German lawyers were very helpful in understanding the situation. They guided us through the German court system and actually wrote a lot of our documents in German, even though we speak no German here at Project Gutenberg. But it was the United States lawyers' advice that was most relevant. It took a little while to find the right lawyers. Not every firm has the needed international expertise. An important lesson learned that we learned through observation is there was definitely a home team advantage to the plaintiff in the German court. This was unduly favorable towards a German-based plaintiff, and the court made decisions that we find to be erroneous. I've mentioned a few of these already. The copyright demonstration was insufficient. The German presence is insufficient. The lack of evidence of any downloads was shockingly insufficient. The German plaintiff was invited to court and given the opportunity to argue in person. I did not have that opportunity. So that's the story. Thank you for listening. And thank you to all the folks who have helped out Project Gutenberg, most recently and over the years. Project Gutenberg is grateful to our legal team. We received excellent pro bono legal advice from Ropes and Gray, also fantastic interaction with the Electronic Frontier Foundation. They see how important it is that small charity online organizations are not subject to international attack as occurred during this lawsuit. I also thank the board of directors of my foundation for support during this lawsuit, and many well-wishers and even donors who expressed belief that Project Gutenberg's mission is worthwhile and that we need to stand against this German lawsuit to ensure that our mission is not endangered. Thank you. And we're back. This is such a privilege to be part of HOPE, and I think people have seen me behind the scenes a few times at this point, and it's fantastic to get out on the stage. I was actually on the stage with Michael Hart, the founder of Project Gutenberg and an inventor of ebooks, in 2006. That was at HOPE number 5. And I'm going to give a quick description, because I was asked about this, of how I even got involved, what my story is of getting involved with Project Gutenberg. I think you'll find it at least a little bit interesting. So I was a university student. This was back in about 1987. I was at the State University of New York at Albany, which is now called Albany University. And I got an email from my buddy, and he emailed me an electronic book. This was 1986. The electronic book was the Millennium Fulcrum edition of Alice's Adventures in Wonderland. So all of a sudden, in my inbox of the day, in 1986, things were a little different then, But in my inbox, I had an ebook, and I said, wow, isn't this cool? Isn't this interesting? And I didn't know where it came from really. It just sort of arrived. But then subsequently, I finished my master's, went on to my PhD, and went on to my first faculty position. That was at the University of Illinois in Urbana-Champaign, Illinois. I was there for my first fall semester in 1991. So this is ancient history, boy. And saw a newspaper article. It was all about Michael Hart. He was holding up a CD, a compact disc, which had a bunch of books on it. Turned out he lived in Urbana. He lived in the same little city that I did. He didn't work for the university, although he had an affiliation with the university. I called him up. I introduced myself, and it turned out that that were a couple of people at the university that we had in common, and people that we knew in common. So I got to know Michael and went to these Wednesday geek lunches in Urbana. Spent some time playing Frisbee, things like this. This was in the early 90s, and basically started getting involved in Project Gutenberg. I was helping create some books. My first book was number 52. We're up to number 60, almost 65,000 now. First book was number 52. You can look that one up, and subsequently got more involved with things like running the FTP server. Later on at Illinois, I was running a service called PrairieNet, a public computing network, and that was the host of Project Gutenberg for a little while. So we worked through a long multi-year process of me getting involved as a volunteer, and sort of a high-end volunteer. And then when it was time to more formally create a corporation to operate Project Gutenberg, rather than being sort of as a side project at these different universities, I was tapped as the chief executive officer, the CEO. So I got involved running this foundation, which is the foundation that got sued in my story that you just heard. And I was also, I didn't mention this, I was sued personally. There were two defendants named: the foundation, which I operate with a board of directors and some other people, but I'm the CEO, and myself personally were named as defendants in this lawsuit. So so I've been the CEO since around the year 2000. In 2011, Michael died. This was a sad occurrence. You can look up on Wikipedia some of his own history, and we have some articles on Gutenberg.org. And since then, I've really been the main guy taking care of the Project Gutenberg foundation, the part that does a little bit of formal paperwork. We have some IRS paperwork that we have to do every year as a charity, and also helping as a volunteer to run the the various things that we do. That includes collection development, and that does include I'm one of the people that do copyright clearances that determine whether something is good or not. So that's a little bit of my own personal history. I think the part that's fun is that I was learning about electronic books in 1986, and I was fascinated. It didn't occur to me. I didn't invent this idea. Michael Hart invented this idea in 1971. Can you imagine? Some of us were alive then, a lot of us weren't, but can you imagine how different the world was then? There were no, smartphones. There was no PC. The IBM PC was invented years later. Even the Apple personal computer was decades in the future. He was on a mainframe using something called ARPANET, the network of the day, that connected Illinois University to a bunch of other places, and decided that he wasn't going to be a programmer. Well, he probably would have been a good one. Wasn't going to be a programmer. But had this access to computing because of a personal connection to the University of Illinois Computing Center. And here's an idea. Let's take this Declaration of Independence printout that he got from a Quickie Mart type of place on the 4th of July. Let's type this up, and then we'll send it. We'll share it with all of our friends on the network of the day. And so that's what he did, and that's how ebooks were born. So quite an inspirational story, I think, and it's a pleasure and a privilege for me to be involved so many years later. So I spent a few minutes now. I thought maybe it would be interesting to tell my story and tell a little bit of the story of Project Gutenberg. And there's an About Us page, as you can imagine, at www.gutenberg.org, which has a lot more details, some interviews, things like that. I think what I'll do now is I'll turn over to some questions, and thanks to Tara for getting these. And making them available. There's a question about whether we've been sued as Gutenberg of Australia or one of the other affiliates. I don't know that Project Gutenberg of Australia had been sued. I haven't heard about that. But we do have affiliates that are in other countries, and these are separate organizations. Basically what happened was Michael gave informal permission to other people to run their own Gutenbergs. And the idea here is that we didn't go into a lot of detail, but literature is a national treasure. And here in the US, that national treasure includes a whole bunch of things. You can think of, Tom Sawyer and Jane Austen and Jack London and on and on. Each country has its own national treasures, and a lot of those, just like in the US, are in the public domain. And of course, many of those are not in English. So other organizations have spun up that have focused on those, and Project Gutenberg of Australia is one of those. And because copyright duration differs in different countries, for example, Australia, Canada have some things that are in the public domain in those countries, but are not yet in the public domain in the United States. And that's a great way of also evening the playing field, because if it's only the main Project Gutenberg in the US, well, there's things that we couldn't make available and we don't make available simply because they're copyrighted here. But in other countries, it might be perfectly legitimate to do so. We had a question that's sort of an interesting legalistic question. You have books on your tablet and you downloaded them in one country, you visit Germany. Are you in contravention of German copyright law? And I think the short answer is, who the heck knows? Who knows? One of the things that I discovered here in this lawsuit is that in the United States, the basic notion of copyright violation is that an individual can violate someone else's copyright by accessing, storing, redistributing copyrighted content, and we know all about this. We know that file sharing is often an issue. Sharing software, music, movies, all that sort of thing. What we found out was that, as I understand it, in Germany, making something available, not accessing it, not using it, but making it available, can be considered to be a violation of copyright law. And of course, in Project Gutenberg, what do? We make stuff available, right? So we always said, well, if someone in Germany is accessing your item that you own, if you own the copyright to this Thomas Mann, well, okay, so go and find that person and get them to stop, block their internet, fine them, whatever, educate them, whatever it is that it takes, or try to sell them your book, but that's your problem, because the violation, if any, is by the person that's accessing it. As I understand the German system, at least, I don't know about other countries, Europe and elsewhere, simply making something available is a violation of copyright, regardless of whether it's accessed, whether it's used, and so forth. So that's pretty interesting. I realized before I take another question, I wanted to summarize where we're at, because I actually had to redact a few of the slides and modify them a little bit, because this is still a story that's not completed yet. I thought it would be. I thought that we would be done by now. And it's been over 5 years, pushing 6 years since the first lawsuit, and a year or so before that, when we first heard from this company, and we told them what I keep telling you in the presentation, which is, hey, we're in the US. If you want to sue us, come to the US. If you think there's issues with copyright violation, find those violators in Germany, because it's not us. So, it's been a long time. We're getting close to the end, though. The court arguments are done. They're settled. As I mentioned, we were called the loser, but in fact, the court agreed with our premise all along, which is we do not need to remove these books. And damn sure we're not planning on removing those 18 books or any other books that are in the public domain in the US. But we're kind of getting to the end, or we're at the end of that court process, and we're having discussions now with Fisher Verlag, or lawyer to lawyer type of discussions, to try to see if we can stop the fight before it comes to the US, because that's just not going to be all that pleasant if it has to come to the US, especially, we think, for the other side. In the case of Project Gutenberg, we have some great friends. I mentioned in my thank you slide, we've had fantastic pro bono legal advice from Ropes and Gray, thanks to Marta and others on the staff there at Ropes and Gray, big law firm. And in addition, we've had a lot of great interaction from the Electronic Frontier Foundation. And as I mentioned in the movie, they see this basic concept, not so much the details of our lawsuit, Germany and these particular authors, but the basic concept of international copyright for jurisdiction purposes and enforcement purposes. This is really important to the EFF, and I just thank them so much for being in our corner. So anyway, the current status is that we're trying to resolve our differences party to party, rather than having to take the next step, be in the U.S. court. And we'll see what happens. We'll try to update our website that I mentioned with news when there is some. It's been moving much more slowly than we thought things would. But it seems that there's certainly a chance that the next step will be to the U.S. court system. And that's certainly where things will get pretty interesting, because we'll have some pretty powerful legal friends and legal advice on our side. And potentially on the other side, we're looking at this international publishing industry, which, as you can imagine, is a fairly powerful group of companies. So essentially, I see going to the U.S. court at this point as a step towards escalation. And this is what I mentioned in my talk. Had we done this 5 years ago, had we not started arguing about the facts of the case and all the things I mentioned, and simply said, look, you got to come to the US. This is where jurisdiction is properly held. Maybe we would have been in a different situation today than we are. Anyway, status is we're trying to work out the differences, and we'll see what happens. Some people wonder about the block of Gutenberg.org in Germany. I'll mention the technological implementation for this. It's we're just using mod security and GeoIP. GeoIP is one of these internet protocol databases. So basically all that happens is if you come into Gutenberg.org, the site gets your IP address, finds out if it seems to be in Germany, and then redirects you to that block page in my slides. We do know how to block individual books. You know, we're fairly sophisticated technologically at Project Gutenberg. But when you have a foreign court making decisions that are just completely repugnant and completely inconsistent with what we always thought to be the case for how international copyright works, we decided that we wanted to get out of that business entirely, and we blocked all of Gutenberg.org from Germany rather than just individual books. And that's a temporary situation. That was while the lawsuit was being fought. We never agreed with the jurisdiction of the court. We never agreed with the findings of the court. But what we didn't want to do was antagonize the court. We didn't want to have the court saying, okay, we told you to do this to make these items unavailable, and or at least inconvenient, not to remove them, to make them inconvenient. And we can't listen to your appeal, you know, while you haven't listened to us, right? So we decided to go ahead sort of strategically. Anyway, we'll see what happens later on with that. I'm going to work through a few of these other questions here. Great questions. One of the ones that just came in is basically talking about precedents. And this was fascinating to me. And I mentioned in the slides, please, if you're ever in a situation like this, do the best you can to get qualified legal advice. And I'm out there. You can, if for some reason I might be helpful, you know, email me, get in touch with Ropes and Gray, with Marta. They're very informed about this. International copyright is not something that you can get from your small town lawyer that works on, you know, your wills and your, you know, property disputes with your neighbors and stuff like that. It's a fairly specialized area. But what we found was, to answer the question, is what we found that there are very few precedents involved in international copyright. And there's a couple of reasons there. Precedents for us, I should say. There are copyright cases, but in our case, it involves something that's in the public domain in the United States and copyrighted elsewhere. That's pretty obscure. That's something that we did not find a lot of direct precedents for. Now, the Germans found a precedent that basically involved something that was copyrighted in both countries, in Germany and Austria. And they said, oh, you know, in that case, we were able to take action in the precedent case, not Fischer-Verlag, but a precedent case. We were able to take action against a foreign entity because it was copyrighted there and it was copyrighted here. And we said, yeah, that's not our situation, right? Our situation is public domain in the US, owned by the American people, and copyrighted out there in another country, not the US. Very few precedents in that, and really none that are directly applicable. So that's part of why I think EFF is involved and interested, is this would be a dangerous precedent if it came to the US and was found in favor of the, you know, the German plaintiff. In other words, if the US court were to elect to enforce the decisions of the German court on Project Gutenberg in the US, and we would have to follow that. That's, you know, that's what you got to do. Then that could open the floodgates for all kinds of other organizations, including our good friends at the Internet Archive, including library projects like HathiTrust. I'm sure some people know of these other projects, even projects like Google Books, where they're doing scanning. These rely on items being public domain in some places. They also rely on something that is not as germane to the Project Gutenberg case here, which is fair use. I'm not going to spend time describing fair use. You can look it up on your own. But that is a, excuse me, that is a different, it's very applicable, but it's different than what was of matter in the Gutenberg case we're talking about. So anyway, short answer is that we would be setting a precedent. We hope it's going to be a good precedent, which is helpful for other organizations well into the future. Let's see, I have a few other questions in the chat here that I'll try to work through. So someone asked about finding Project Gutenberg books out there. So it's not so much about the case, but just generally people find Project Gutenberg books out in the wild, reselling on Amazon, print on demand, maybe they're making derivative works. And is that allowed? And the short answer is absolutely yes. There's two asterisks, two exceptions. One is that we do have some copyrighted works. So for example, we have a translation of Hermann Hesse's Siddhartha, very popular book, but the translator maintained copyright. It was a translation from a few years ago for a book which is in the public domain in German again. It's in the public domain in Germany, or it's a German book that's in the public domain in the US. And he made an English translation. So we have, I don't know, maybe 1,000 or so books that are copyrighted. So those cannot be resold. Those are still copyrighted. The copyright's owned by whoever donated that book. But for the things that are in the public domain, the other asterisk is that Project Gutenberg is a registered trademark. So if you want to trade on Project Gutenberg, in other words, say the Project Gutenberg book of Pride and Prejudice in your Amazon store, then you have to pay royalties. And there's a sort of a legal small print thing that you can find on the Gutenberg.org site that describes the royalty schedule. But almost no one does that. And in fact, because what they can do is they remove our name, they remove the trademark, they remove the header, the footer, remove that mention of Project Gutenberg, and what's left? Right, exactly. What's left is the stuff that's in the public domain. So if you have Pride and Prejudice, the top of our Pride and Prejudice says, this is a Project Gutenberg book of Pride and Prejudice released on such and such a date. Here's a language character encoding. You read the book, and then at the bottom, there's some small print, this license that I talked about. So get rid of the stuff at the top, get rid of the stuff at the bottom, and what's left is in the public domain. And we do not own that. The fact that we worked hard to digitize it doesn't give us ownership over that. And that's something else that you can find on our site. It's an interesting piece of research. Sweat of the brow, labor, does not create copyright. We've heard in some of our other talks things related to patents, ideas, which are potentially patentable, or implementation of ideas are potentially patentable. Those don't get copyrights. What gets copyright is expression by authors. So the most famous case of that is Feist Telephone Company, or Rural Telephone Company versus Feist Communications. And this is a case where the basically what was issue was more or less a phone book. And the resulting judgment was that, hey, you might have worked really hard on this directory of numbers and information. You might have worked really, really hard, but you did not author it. You did not take ideas and decide how to express those. It's the expression of ideas which is copyrighted. And you can read that as it's phrased by the founders of the country in Article 11 of the US Constitution. So that's where copyright comes from. So so sort of a longish side bar conversation there on what gets copyrighted and what doesn't. But when you have a reseller which is stripping out that stuff and selling Pride and Prejudice on Amazon, great, we have no objection to it. We'd like it to be cheap. We'd like it even better if it's free, but we don't own it. If they're doing that with the Project Gutenberg name and not paying royalties, then they're violating our trademark. And unfortunately, that does happen. And I can tell you that Amazon is absolutely the worst offender for this, partly because they are, of course, a monster. They're a behemoth, doing all kinds of things that we know about. And we even have some talks at Hope about some of their activity, but also because they don't really police their resellers very well, and sometimes barely, if at all. So what that means is you have an individual somewhere that sets up an Amazon storefront, grabs, or if you will, steals the Project Gutenberg items as is. Maybe he takes our EPUBs or HTML files, maybe makes them into a PDF. Okay, that's sweat of the brow, but then doesn't pay royalties. And what happens? Well, you can guess what happens, because when someone downloads that book, maybe they paid $1.99, maybe they paid $12. They download that book, they open it up, and it says, this is a free book. And if the small print, it goes into a lot of detail on why it's a free book. And who do they complain to? Me, right? Or they email the help desk, or get us on social media or something like that. So these, that's a whole separate presentation, complaining about Amazon. But luckily, there's some other people that are doing complaint about Amazon talk at the conference here. But anyway, the fact is that the reuse, the reselling, making derivative works from public domain, absolutely okay. Using the Project Gutenberg trademark without following the license terms, not okay. And we do pursue those situations when they occur. But we encourage, boy, do we ever encourage giving stuff away. That's what we're here for. We like to make stuff, we like to give it away. Let's see, we have a couple of other nice questions. There's a question about new authors or contemporary authors that might want to release their works for free on Project Gutenberg. And we have a site for self-publishing. It's called the Project Gutenberg Self-Publishing Portal. And it's at self.gutenberg.org, S-E-L-F, self.gutenberg.org. Unfortunately, that site is currently inoperative. They had a back-end failure, and the front-end works okay, but they can't add new content. Hopefully that'll be fixed soon, and we will make it available. We had a question about questioncopyright.org. I'm afraid I'm not familiar with that, so I won't comment on it directly. I'll look later. But one thing that might be of interest is the Project Gutenberg collection development policy. And I think this is a little bit tangential, but I'll mention it anyway. You can find the collection development policy at www.gutenberg.org under the how-to section. We worked really hard on this, and it was only within the last year. We never had a collection development policy. I don't know why, but we finally got it up, and we worked very closely with our excellent colleagues at Distributed Proofreaders. Distributed Proofreaders is where most of our books come from. By the way, side note, volunteer, help out, www.pgdp.net. Project Gutenberg Distributed Proofreaders. This was a crowdsourcing idea that was from 2002. So it was a pretty early crowdsourcing idea, but that's where you can help proofread. Anyway, collection development policy. We subscribe to something called the Freedom to Read principle from the American Library Association, FTR, Freedom to Read. Go and look at this stuff. You will love it. If you're into Project Gutenberg, you're into free books, free culture. The freedom to read was really helpful in our collection development policy. And what it said was all books, all expressions of ideas must be made available. The fact that some of those are repugnant, questionable, dated, racists, all these complaints. We know about this, all this terrible literature. I used Uncle Tom's Cabin. I used Mein Kampf as examples. These all need to be available, because for them not to be available is worse. Doesn't mean you need to enjoy them, like them, celebrate them, nothing like that. Maybe it's a little like the Confederate statues, where they might be available. Let's put them in a warehouse somewhere. Let's not celebrate them. But we don't want to forget that history, that literature. So I very strongly recommend taking a look at that freedom to read principle under the collection development policy. It's very illuminating. And I will try to look up the questioncopyright.org afterwards. We'll just take one or two other questions, and we'll try to wrap up. I really appreciate all this interaction and, of course, the interest and support in this lawsuit. So there was a question. I think maybe we'll get back to the lawsuit, just as last one or two questions. How relevant is it that we don't have any download records? Let me explain part of why we don't have download records. The starting point is, to be clear, if you were in the US court and saying, hey, someone's violated my copyrights, the judge would ask two questions at the very beginning. Number one is, who are you and what copyrights? Do you own the copyrights? In the German court system, that was not adequately demonstrated. It was partially demonstrated after the lawsuit began, and it was inadequately demonstrated after 3 tries, 3 appearances in court, that the plaintiff was given the opportunity to make. And what it came down to was this heir, someone that was a descendant of the authors, saying, "Oh, yeah, it's okay," and saying it in German. I won't try to do a German accent, but he said, "Oh, this is a publisher we work with. We let them do what they want." Right? The paperwork trail was almost entirely absent on this. They added paperwork as the case proceeded. So in the U.S. court, they'd say, "What copyright? Do you own it?" And then they'd also say, "Well, have you been damaged? Were you selling this and now you can't sell it? How much money did you lose? That matters. How many downloads occurred?" In the German court, it didn't matter. We said, look, we are a library, an online library, and like so many online libraries in the United States, we don't keep download records. All access is anonymous. The short answer of why that is our friend, the Patriot Act, post 9/11 Act, which gave unlimited ability for law enforcement, government agencies to seize records, and also made it possible through these national security letters to do it without even disclosing that they were seizing records. So long story short, we don't keep download records. We do not have them. We don't know if anyone from Germany has downloaded these 18 ebooks, because we just don't keep those download logs. We use Apache web server and standard technologies which generate the logs, and we keep them for a short period, run some analysis, so we have a nice little summary of number of downloads and stuff like that, and remove them permanently. So we cannot give the count. Anyway, the German court just didn't seem to care, is the short answer to that question. They didn't seem to care that there were no record of downloads. There was no evidence that anyone had downloaded. They didn't at all care about whether the plaintiff had suffered any loss. Like if in a regular sort of legal situation, you say, what's your loss? If you were selling $10,000 last year and now you're selling only $5,000, then maybe it's because of someone distributing your book. But we don't even know if they're selling these things in Germany, let alone anywhere else. So anyway, that's the interesting situation differences between the U.S. and Germany. And we did get to learn a fair amount about U.S. law, but I'm not a lawyer. I didn't say that at the beginning. It's pretty obvious I'm not a lawyer. We're getting some good legal advice, but also, as I said, it's important to note that this is not a mainstream situation that we're dealing with here. It's a relatively obscure area, copyrighted in one country, public domain in the other country. What really matters, and the takeaway for me, is what's up with a big international publisher bullying my small public charity from a continent away on something that I'm doing, which is perfectly legal where I am, and from my point of view, of course, perfectly wonderful. A very much publicly facing and publicly benefiting activity. So we'll leave it at that. We're at the end of my presentation. We have an exciting keynote coming up next. Thank you. Thank you for your support, for listening, for your questions. It's been a pleasure. I'm so happy to be part of Hope, and let's call it a day for now. Thank you again.